Aboard! Aboard!
On page 90. I just want to confirm that on page 94, the motion for the hearing, the vote taken was 5-4 against. If you chose someone other than Kingsbride, is that correct? That's where everybody remembers?
Yes.
Okay. And then once Kingsbride was allowed to be the officer, it went to 8-1, and the only difference between the motions was the addition of Kingsbride.
As far as I recall, sir, yes.
Okay. Thank you.
And it wasn't an 8-1, it was an 8-0-1, I believe.
Correct. Thank you.
And I don't know what page it was on, but I just want to confirm that you at one point said you are the judge and jury.
Page 87.
Thank you. Is that correct?
Most definitely. Thank you.
So a motion and a second on the floor to approve the minutes from March 25th regular meeting. All those in favor signify by saying aye. Aye. Opposed? We're going to handle that one first. Page 7. I need a motion and a second to accept the name clearing hearing report of the hearing officer, Brian Taylor, and to make said report available for public review. So moved.
Second.
Smiley? Comments? Mr. Taylor. Mr. Taylor? Mr. Taylor. I move the motion as consideration up for you to discuss the name clearing hearing. So at this point, we have a motion and a second on the floor. Mr. Bradley has a question or wants to do some discussion, so we're going to get into the room.
Well, sure. So the question
I'm actually going to ask the board, if you don't mind. So, as a board member, I sent in a list of questions to be reviewed. Did they get reviewed? They're not part of my FII packet, so I'm wondering if the rest of the board saw them.
Are you referring to attachment A to your letter?
Yes, sir.
And I have some answers for it, if you'd like to hear them.
Can we get them in writing instead?
The board votes for me to put them in writing, I'll put them in writing.
Did anyone else read these questions or see them?
I saw them.
Can we get them in writing?
I mean, I saw them.
I didn't see the responses from the...
As a sub-motion, then I make a motion that we get the solicitor to physically write.
Let's do that under new business, Mr. Bradley. Okay?
Well, we're in the middle.
But
No, I'm going to have them read them. So let's just spare the time, let's get them in writing. I make a motion that we get the solicitor to answer the questions that the board asked, or that this board member asked.
You asked.
That this board member asked in writing. Can I get a second on that motion, please?
I'll make a second. Ms. Wagner, do you have that? Okay. All those in favor? Discussion?
I have a comment.
Yeah.
I would encourage the, smile all you want. Whatever.
No, I was going to make sure he gave public.
Laugh and smile all you want. I have a comment on that. Again, you know, why waste time? Because if we now have to wait for these things to be put into writing, is there going to be a subsequent motion that we delay the acceptance of that report? Also, I would simply say if Mr. Bradley wanted to know more about the hearing, he would have shown up to the hearing and been here and been a part of that. Why give him something to put into writing that can be edited, debated over social media, spun, twisted, what have you? I think a lot of this was already addressed. my 2 cents.
Thank you. Any other further comment?
I have one comment. When I was invited to,
This is on the attachment A item, Joy.
okay,
So is that what you're speaking of, or you're speaking of the whole report?
I just wanted to respond to one thing that Mr. Hauser said just now. He commented on Dave Bradley not being at the hearing, and it's my recollection when I looked at the email that I received from Bill Schwab telling various people about the hearing, I don't believe that I saw Dave Bradley comment on that email.
8 out of 9 board members were present. Mr. Bradley has written emails asking how does he participate in the hearing as early as April the 1st. And now magically the day of the hearing, he doesn't know about it?
Any further comment? So I have a motion and a second to provide in writing the answers from the solicitor to the attachment A. All those in favor signify by saying aye. Roll call vote, please.
I have a question. We would be able to discuss about, so are we entitled to what attachment A is as public?
Attachment A is a list of,
No, these ones are my answers.
I'm just saying how many questions there are. A list of 21 questions concerning some activities around the name clearing area.
And honestly, it's Mr. Bradley's email, so he can forward it to whoever he wants.
I'll do the roll call.
Yes, please.
Mr. Waymans?
No.
Mr. Andy Answer?
No.
Mr. Joy Beers?
No.
Mr. Richard Belts?
Yes.
Mr. David Bradley?
Yes.
Mr. Stephen Holland?
No.
Mrs. Gail Mahler?
Yes.
Mrs. Rita Spinelli?
No.
Mr. Larry Stern?
No.
So that's 3 yes, 6 no, motion denied.
Okay, so I have a motion and a second currently on the floor to accept the name clearing hearing report of hearing officer Brian Taylor and make said report available for public review.
I would like to make a comment about that before we take the vote. As was discussed earlier. Oh,
We can't hear you now.
Thank you, Joy.
Great. As was discussed earlier, Mr. Tyler was explaining kind of the premise of the hearing, and that Mr. Hauser called witnesses, and Mr. Schwab also called witnesses. And I personally think that Bill Schwab could have done a better job presenting the other side of things by inviting other witnesses, as Mr. Kemmer had alluded to.
Thank you. Mr. Bradley?
I'd like to state on the record that I was not invited, nor was I privy to the time or date of this hearing at all. It was requested many times to find out that information. It was not presented to me, even after direct request. Secondly, I have found out that the witnesses associated with that hearing were also not invited by our administration. So my question is, Mr. Hauser called the board juror, but I believe in this situation they're the adjudicative authority, right? So they are part of judge and juror, correct?
They're the juror.
They're the juror.
Their most equivalent position is the juror.
Okay. So how does Mr. Taylor write a report for the jurors? Why did Mr. Juror write this report?
Well, it's written as a recommendation, just by way of introduction. My name is Brian Taylor. I've been an education attorney for the last 10 years, a litigator for the last 30 years. I specialize in mediation, arbitration. And I was a hearing officer last week. It was conducted as an informal hearing. I did not call to choose who the witnesses are. I'm not in charge of the notice. I just proceed over the orderly processing of the hearing. I deal with questions of law, questions of evidence. So exactly what is your point that's directed at me?
So I'm asking, what authority do you have to write the report for the benefit of this board? Did they ask you to?
Well, exactly, I'm the hearing officer. And by right, this hearing had to be held. Under the federal constitution, under the state constitution, under the threat of having to pay compensatory damages, nominal damages, this type of hearing is commonly held, a liberty interest hearing. It is not an unusual procedure. The district had no other choice but to call.
But I understand that. So, again, this report was generated by yourself.
Correct.
Who authorized you to write this report?
I'm
what authority did you
I'm an
write
officer of the court. I'm a hearing officer. I'm authorized to write a summary or recommendation of the hearing.
And who was the authority that gave you that authority? Was it the board, or was it the administration, or was it school code?
Mr. Bradley, it's just, I'm a hearing officer. It is my job.
To write this report?
To write a summary. To write a summary of the hearing.
Okay.
Correct.
So
I didn't have to decide the case. I write a recommendation. It's up for acceptance.
okay. And then at the same time, you were invited to be this hearing officer, correct?
Correct.
Thank you.
Mr. Taylor?
Yes.
You said you deliberated over these, or
That's right.
ruled on many of these in the past, these type of hearings.
Correct.
Okay. In your professional past, how many have, in your eyes, did any of them ever have a parent a part of like this type of deliberation where it was almost directly involving a parent? Or is it typically that they aren't involved because it is a school matter, like Mr.
Well,
Stewart
each
said?
case is so fact-specific. It varies from case to case. In this particular situation, we have an administrator is one party, the district is another party. It varies from case to case. I couldn't give you a simple answer.
So my question is, if Mr. Bradley is saying these things based on things that he experienced with the meeting, okay, which was in direct conjunction of that meeting, do you think that the people, all parties in that meeting would have been beneficial to the interview?
That's not my call.
I understand.
I'm a hearing officer.
It's just
Yeah, I'm a hearing officer.
in your past practice.
I can't, sometimes yes, sometimes no. It's okay specific.
Okay,
Yes, I couldn't give you an answer.
No problem.
I have commentary on that because of misunderstanding again. First, I'll address what Ms. Beers has said. Ms. Beers cannot effectively comment on what was done during the hearing because she was sequestered as a witness. She was not able to observe the job that Mr. Schwab did, with the exception of when she was called to testify. That being said, the parent meeting that Mr. Kemmerer is bringing up, again, is not the matter that was in question at the hearing. Mr. Kemmerer has established that his son was searched. He has done this numerous times in public meetings and social media over the course of the last 10 months. He had a conference that evening, which Mr. Bradley attended, and made various inflammatory remarks. Those remarks are not the basis of this hearing. Mr. Kemmerer was not present during the search. However, he and Mr. Bradley subsequently categorized it as a strip search. I would also add that the quote-unquote evidence from that is a definition of strip search that comes from Wikipedia. And the Wikipedia page that Mr. Kemmerer himself posted has over 400 edits by anonymous users on it presently. This was posted on social media for public consumption, and this was repeated by Mr. Bradley over the course of the last 10 months. My issue is not that the search happened. My issue is not the parent-principal conference that happened. My issue was Mr. Bradley's actions after all of that occurred. He provided evaluation of my job performance. He provided ways that I could improve, including in one email it was taking an emotional awareness test. And then he entered into various forms of public record, meetings such as this, board minutes, committee meetings, emails to my superiors, emails to board members, and most recently over the last week, emails asking questions about this process to the press, which should cause every employee in this district to have a cause for alarm. He entered those into public record. So he identifies behaviors he doesn't agree with. He involves himself in ways he thinks things can be changed, and then creates a record of that. That was my concern. In my opinion, and this is why I did not call Mr. Kemmerer or his son as witnesses, that part was not connected to Mr. Bradley's subsequent evaluation of that work. That's where there's misunderstanding. I'm not debating you in a public meeting, sir.
I'm not. My question is.
I was talking to Mr. Bradley, Mr. Kemmerer, I apologize for that.
So, real quick, the questions that were asked in conjunction to the actual search, I'm understanding that, I'm sure Mrs. Howland was asked questions about that particular incident and how it went. And because of her accounts of it being an eyewitness to the search. My next question is, if her accounts of that eyewitness search were so prudent and pointed to your deliberation of what you feel, how to move forward, why wouldn't the third party in the search have that same opportunity? And question, because we could clear things up potentially to support what Mr. Hauser is saying.
Well, I understand that, but I mean, I can't go into what Ms. Howland said during the proceeding, because that's privilege as an employment matter. I'm here just to address the procedure that occurred. The content of the hearing, I'm not allowed to go into beyond findings. Should this be accepted and approved?
So, I mean, here's my question. We've been dancing around this. I don't want to put your son up for questioning. I don't think that's appropriate either. You, Mr. Kemmerer, have made comments publicly, social media, when you're out and about, when you're here at board meetings, about this whole thing, but yet the entire story has never really come out. Legal definitions of strip searches are available. Why have those definitions never been applied? I brought a few up. So why don't you explain what happened in that search? Or are we just going to go onto Wikipedia and type in strip search to Google and paste the first thing that comes up and call that your diligence and research, because that is what you did. You want this to go away. Let's stop beating around the bush.
Let's get the other questions. I know Mr. Bradley.
Yeah, I have a question.
One question. So, because I don't want to, because he's here to answer questions on process, procedure, and everything that took place. So I want to make sure all those questions are answered.
The ones that are on my list you're saying, or not?
That's not what I said.
I like to get those answered, but, so the question I have is, this hearing then was about my actions in relationship to Mr. Hauser, is that correct?
Your actions, there were certain accusations made. Yes, we did review those.
Okay.
So, in conjunction with discipline that was issued upon him. So yes, there was a name clearing which he's entitled to have. He's entitled to refute those claims, those accusations. He was given that form to do so. You, at most, were just a witness. And this whole concept that you weren't invited is completely disingenuous, because you and I went back and forth with a whole bunch of emails for the whole prior week before that, to the extent that you asked me about lawyers, about evidence that you needed to submit. So for you to claim that you were unaware and unprepared is completely disingenuous to everyone in this room.
Unaware. And the reality was, we were never invited to the meeting, Mr. Kemmerer, his child, or myself. But here's the question I have to ask.
But I'm a hearing officer. I'm not responsible for service of notice. Mr. Bradley, you were aware of that.
Not at all. Thank you. Thank you. You were not invited. And the service of the hearing should be documented. And
what are you free to do that?
And we did it since then, and we found out that it was not, I was excluded from the meeting notice. We only found out because Rita said she wasn't going to make it, at which point people then became aware that the meeting was even happening,
because the service that was provided, not to myself at all, but to other board members, was not to their official address. So there was some unique ways that this,
In the laws,
that's fine.
you could have.
I was not
Constructive
notified.
notes are here.
I was not notified of it. Thank you.
You responded to my emails about it. I wrote you a letter about it.
In advance of the hearing taking place, we worked
I'm not
together
gonna
all
argue
day.
with you. I'm not gonna argue with you.
Never told the neighbor ever. But here's the question I have. The Pennsylvania School Code confers no authority upon an individual school board member to act unilaterally under the guise of carrying out responsibilities of a board as a whole. The law is clear. So what he's describing is an action of an individual in an individual capacity. So why would this board incur the cost to adjudicate his concern that an individual citizen was critiquing his behavior?
I'm not gonna go to, that's content, but I'm not so certain that all your actions were done as an individual citizen.
Is there any way that my actions could be construed as an action of the board?
You and I are going to debate.
I'm asking is, as a lawyer, as the officer.
I'm not your lawyer. I'm here to take the, no.
You are.
I'm here as a hearing officer.
Okay, so
I'm
hearing officer.
here as a hearing officer.
Is there any method to which an individual board member can take the action of the board?
That's for your solicitor to answer. I'm here as a hearing officer.
I appreciate that. Can we get that answer, Mr. Filer, please?
I just would like to comment about that comment is, on many occasions, you were here at policy committees and in different committee meetings as a board member, because you are part of those committees where you're making recommendations to move something to the full board, and you had comments regarding Mr. Hauser made to the point of where I believe you had a video posted to where you turned your own camera to focus him during one of those committee meetings. So absolutely, you are here as a board member.
I don't have that authority, sir, at all. And Mr. Filer, can you please explain that under Bangor
We're
Area
not
School
questioning whether or not
versus
you have the authority, we're questioning that you are acting in part of a board member because you run that committee at a public board meeting.
That's your opinion, but let's get the one that's official.
I know because you hide behind the camera when you're sitting at these meetings and film other people, but it's still you there as a committee member and a member of the school board.
Mr. Bradley, the fact that you sit there with a name tag that says Citizen Dave Bradley does not mean you're not in fact a member of the board. And when you take actions against the employee, it comes back negatively to the board. So the fact that you don't have the authority to do it should be telling you that you shouldn't have been doing it in the first place. You did that anyway.
I have every right to review the actions of my government.
And as a board member, you have a contractual obligation not to violate the collective bargaining agreements.
I am not a board member.
Yes, you are!
Can I get that
There's no authority placed upon me as the board.
Can we call a question, please?
Request a roll call vote on the approval of to accept the name clearing hearing report of hearing officer Brian Taylor, who makes a report available to public review. Thank you. Motion F.
Mr. Andreaser?
Yes.
Mr. O'Beers?
No.
Mr. Richard Belts?
For the record,
I'm
if you
sorry.
were- I'm sorry to interrupt this.
Go ahead.
I would advise anybody who was a witness or did not participate to abstain. Again, be my advice, you have no obligation to follow it.
Do you want me to start over?
Please do. I'm sorry for interrupting.
Mr. Andreaser?
Yes.
Mr. O'Beers?
Abstain.
Mr. Richard Belts?
Yes.
Mr. David Bradley?
I do not condone the illegal use of educational funds on illegal activities taken by a majority of this board. I won't be a part of it, so I vote no.
Mr. Stephen Holland?
Yes.
Mrs. Gail Mahalik?
No, that's her choice.
Mrs. Rita Spinelli?
Yes.
Mr. William Metz?
Abstain.
Mr. Larry Stern?
Yes.
Okay, so I have 5 yes, 1 no, 1 absent, and 2 abstentions. Motion carries.